time. That's something I spoke about before, where I find it so interesting. I like it, actually. I like the fact that in Trinidad, one greeting, one salutation is not enough, especially with people you know. It's not just good night, it's good night, good night, good night, good night. Yeah, you know, night, night, yeah, good night, good night. And morning, yeah, morning, 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 morning. You have to say it a few times to you have to say it a few times to really get the point across. J. Chris, how many lives are you a moderator on, sir? How many lives you have out there? And why am I not at the first priority? Which other live is at a higher priority than the Mindful live? Hot, hot, sweet, sweet for emphasis. Yeah. And you have to emphasize the mornings. You're emphasizing how polite you are. Morning, morning, good night, good night. All right, welcome to Mindful Live number 44. It is the 23rd of February 2022. It is Wednesday, the 23rd of February. Hump day, middle of the week. How's the week going? What's up, Mr. King JC? Welcome to Mindful Life. It's nice to have you here. Tonight, we're going to be talking a bit about bail. For those of you who are familiar with the news as it has been going on so far, our appeal court made a ruling that has some people not very happy. They made a ruling that made it possible for people out there charged with murder to be able to access bail, at least to go to a judge and request to get bail. Appeal court warned of grave injustice if bail for murder decision not suspended. So once you're in the live, of course, make sure to hit that like button, double tap that screen if you're over on TikTok, whatever the like button is, whichever live you're tuned in to, make sure to hit that, and subscribe if you're over on YouTube. If you're not over on YouTube, afterwards you can go over on YouTube, follow and subscribe Nathan Springer on YouTube to keep up to date with any of the lives you may have missed out. As usual, the merchandise is on sale. The Mindful t-shirts, Mindful caps. Message me if you would like to order some, as usual. Yes, appeal court warned of grave injustice if bail for murder decision not suspended. You are so says, do you have dreams into making Mind Live really bigger, like interviewing people? Wish you could reach that goal, like something like an open studio? Yes, that is the goal, that is the mission. Right now I'm looking to get that studio set up to be able to facilitate such a thing. Right now where I am, you can't have multiple people here, but ideally I would like to be doing this, whatever we're doing here, as we speak, as we discuss the news, as we discuss information. Ideally I would like it to have some other people in studio with me speaking about the events right there, and you could have rotating different people being interviewed, different people speaking about the information and news of the day. Yes, that is the intention. So purchase some t-shirts, donate some if you have that interest, and that is where I'm heading either way, whether you purchase them or not. The state has launched a multi-pronged plea to the Court of Appeal to suspend its decision, which allows anyone accused of murder to apply for bail. The court's order has been temporarily suspended, but some submissions on a longer suspension will be entertained on March the 3rd to allow the state to appeal Thursday's decision to the Privy Council. The application for the suspension was filed on Monday. It contained affidavits from the Director of Public Prosecution, the head of the Legal Secretariat of the Office of the Attorney General, and the Acting Permanent Secretary of the Ministry of National Security, all of whom spoke to the hardships various state departments will face if there is not a longer suspension. Yes, I am COSI 06. DPP Roger Gaspard, Senior Counsel, said there would be a grave risk of injustice if the suspension were not granted. So what they are asking for here is for a longer suspension of this ruling. The ruling allows it, as I said before, for those accused of murder, for those charged with murder, for those who have their cases currently in the court charged with murder. It allows them to now go and request bail from a judge. And several different people in the legal fraternity, in the justice system, have joined together and written and written a letter asking that they suspend this ruling for a little while longer. The ruling is suspended right now for only a limited period. What they want is for that ruling to be suspended for a longer period so they can appeal the ruling to the Privy Council, which is the highest court, not of our land, but in our justice system. So after our appeal court, if you don't like that ruling and you'd like to appeal that ruling, you appeal that to the Privy Council out in England, and they're asking to suspend the ruling for as long as it takes, I suppose, for them to appeal that ruling to the Privy Council. The DPP says there would be a grave injustice if the suspension were not granted. He highlighted 3 main points to support his plea. They included the current temporary halt on jury trials because of the pandemic, inadequate staffing levels of the DPP's office, with only 46 available attorneys for the 13 magisterial districts, high courts and appeal courts, and inadequate infrastructure to support electronic monitoring. So, 3 things the DPP cited as his main reasons why, as it stands, you need to suspend this ruling, and we need to appeal this ruling. And I suppose he's saying that the ruling on a whole very likely should be changed. That's the hope, I suppose he's saying there. And the 3 reasons he cites is basically staffing issues, and especially staffing issues as relating to the fact that they are not in-person trials, they are not jury trials right now. The second reason being, the first reason, being the fact that they are not the jury trials right now. The second reason being the staffing problems, and the third reason being inadequate infrastructure. And when he speaks of infrastructure here, he's talking about the electronic monitoring unit. This was confirmed by the acting permanent secretary in the National Security Ministry, Gary Joseph, in his affidavit. Joseph spoke of the strain on not only the electronic monitoring unit, EMU, but also the probation officers department and the forensic science center. He said the EMU staffing levels were already stretched and exacerbated by the pandemic, and the unit was still in its infancy stages. He admitted it was not envisaged in the initial stage of the program that electronic monitoring would be extended to high priority offenders, nor did it have the proper equipment to do that. The cost of getting the appropriate devices to do this would be in excess of $10,000 each, he says. So, according to them, they do not have the sufficient infrastructural setup to even have electronic monitoring. So if these murder accused people were able to access bail and somehow were able to leave the jail system, you would suppose that at least what you'd want is some kind of electronic monitoring on them. But we don't have what it takes to be able to do that. The resources required to do that and keep up to date with them, we do not have sufficient of it. Now, let's see exactly what was the problem that the DPP himself raised. DPP raises concerns over state's ability to process bail for murder accused. DPP Roger Gaspard has raised concerns. We know that. Gaspard raised concerns in an affidavit filed in relation to an application. We know that also. Gaspard suggested that his office's ability to resist such applications would be hampered by the ongoing inability to host jury trials during the COVID-19 pandemic. Even though I am aware from news reports that Barbados, Guyana, this is the DPP speaking here, Barbados, Guyana and Belize have all restarted jury trials, prosecutors, though they may be ready to present their cases, cannot reliably advance to the judge or master hearing the application for bail a firm trial date for any murder accused opting for a jury trial. So we do not have access to jury trials right now. And in that case, if a murder accused requests a jury trial, the prosecutor cannot even give a plausible date for when such a thing could happen. Gaspard referred to Chief Justice Ivor Archie's annual speech at the opening of the current law term last November, when he admitted that only 30 judge-alone trials, 8 of which were murder, were completed during the previous law term. So very few trials, especially murder trials, can be completed in this judge alone state. If someone requests a jury trial, I suppose you'd have to facilitate them. And currently, we are not doing any jury trials. I aver that it is difficult to see how the mass exodus from remand, which the court in the judgment did not think likely at paragraph 91, could be prevented in the absence of the immediate resumption of jury trials, Gaspard said. Referring to staff shortages at his office, Gaspard noted that while Cabinet approved a new organizational structure with a complement of 137 attorneys in May 2013, his office currently only has 50 attorneys. He stated that of the current staff, 2 attorneys resigned recently, with 2 others being unable to be deployed to court hearings due to medical issues. I am aware of steps being made to fill vacancies at the office of the DPP. However, at this time, where it's almost 3 times under its cabinet sanctioned strength, the DPP's office will struggle to meet the tide of applications which will flow from the judgment, with a clear risk of injustice in treating with them appropriately as follows inevitably from the law of diminished returns, he said. So they don't have enough staff to even administer the influx of requests for bail that very likely would come in right as soon as this judgment is proclaimed. All these matters require extensive preparations and cannot be completed within a short time frame, Gaspard said, as he noted that the assistance of police officers from the court and process branch would be required. Gaspard also raised concerns over the ability of the electronic monitoring unit of the Ministry of National Security to provide electronic monitoring to accused persons who may be granted bail. This is another thing that was already said before. He noted that his office would require such monitoring for all such murder accused, as they should be considered flight risks because they still face the possibility of the death penalty if eventually convicted. So, because of the position these men are in terms of their charges, they should all be considered flight risks. And if they are all considered flight risks, you would all want them with electronic monitoring. And we do not currently have enough electronic monitoring to keep up with all the murder accused on trial. Problems abound. In the expected event that there's an avalanche of applications, this will put additional strain on the existing staff and financial resources which were not budgeted for in our draft estimates for 2022. That's another point there. Understandable. But here's not but. In addition to what the DPP said previously, he went on to phrase it, and this was part of the problem. This was something that kind of stood out to me when I heard this way how he phrased it. This was over in the Express article. They had this quote from him. The DPP pointed out he also found it difficult to understand that there wouldn't be a mass exodus. It is submitted, this is the DPP speaking here, it is submitted that the enforcement of the judgment at this time creates a grave risk of injustice because of the unfair advantage which persons accused of murder would have in bail applications owing to the prevailing practice direction. So he phrased it as being an unfair advantage to the murder accused because they would now be able to access bail, but there wouldn't be enough prosecutors to handle all of this. The topic right now is bail for the murder accused, and the DPP's comments regarding that, and saying that right now, 3 main issues they cited: the understaffing issue, the fact that there are not currently jury trials available, and also the lack of infrastructure as regards to the electronic monitoring system to monitor electronically the people. If the murder accused do get access to bail and they're on the outside, they would need some kind of electronic monitoring, and we do not currently have enough of it to monitor all of them. According to the numbers they say, there are around 1,200 currently that are charged with murder, and we have less than 50 prosecutors. If all of them apply for bail, the prosecutors could not possibly, they wouldn't possibly be able to keep up with all of these cases. But whose problem is that? Whose problem is that? If I am charged with murder, I am not convicted of murder, I am charged with murder, and I am innocent. However it happens, I end up just getting tied up in this system. Can you then see that, well, unfortunately, Mr. Innocent Guy, right now we are awaiting trial. We cannot give you bail. You have to stay in jail until we figure out how to undo this system, because we cannot let all the other guilty people out. All the innocent would have to stay locked in there with the guilty, because we cannot let the guilty out, and we do not have the resources right now to process all of you. So here's what you'd all stay in there. Is that how the legal system is intended to work? I will answer that for you. No. Our current legal system is based on the British legal system. And the British legal system has hundreds of years of history showing what is intentioned by this system. And there's a key factor inside of this, something that I mentioned today inside of my contemplation, something called Blackstones Formulation or Blackstones Ratio. I'm reading this from the Cato Institute. This is a think tank over in the United States. I believe it's a libertarian think tank, but they have some nice concise information on it here. Blackstone's ratio: is it more important to protect innocence or punish guilt? When crimes occur, societies often cannot know for certain if a suspect is guilty or innocent. Consequently, societies must grapple with what type of mistakes they will tolerate more, sometimes punishing or scrutinizing innocent people, or sometimes allowing guilty people to go free. So this is a problem. It is a problem. You have a type 1 and a type 2 error there, and you have to decide which way you are willing to lean on more. Would you be willing to see more innocent people punished just to make sure that more guilty people do not escape? Or would you be willing to see more guilty people escape just so that innocent people are not punished? I think that's a worthwhile system. That's a worthwhile question to ask yourself. The American system, grounded in the British common law, has long erred on the side of protecting innocence. Thus, we presume an accused person's innocence until they are proven guilty. As the preeminent English jurist William Blackstone wrote, better that 10 guilty persons escape than that one innocent suffer. This principle can also be found in religious texts and in the writings of the American founding fathers. Benjamin Franklin went further, arguing it is better that 100 guilty persons should escape than one innocent person should suffer. And I believe there was a Jewish, history class, and I believe there was a Jewish jurist before that who went as far as saying it's better that 1,000 guilty people escape than one innocent person suffers. Other notable historical figures have worried more about punishing the guilty. For instance, German Chancellor Otto von Bismarck is believed to have remarked it is better that 10 innocent men suffer than one guilty man escape. Che Guevara and 20th century communist movements in China, Vietnam, and Cambodia also employed similar reason. Yes, communists generally lean on the opposite side of that, where they believe it's better you punish the innocent than you allow the guilty to escape. And I think this is a question we really need to ask ourselves. Which side are you willing to lean on? Are you willing to allow innocent people to be punished just in pursuit of making sure all the guilty people are punished likewise? I think personally me, I err on the side of allowing guilty people to escape in pursuit of not wrongly punishing innocent people. And I think that is the better moral decision, and it is the better logical legal decision also. Let's dig a little further into this Blackstones formulation. The principle is much older than Blackstone's formulation, being closely tied to the presumption of innocence in criminal trials. An early example of the principle appears in the Bible, Genesis 18:23 to 32, as Abraham drew near and said, "Will you consume the righteous with the wicked? What if there are 50 righteous people within the city? Will you consume and not spare the place for the 50 righteous who are in it?" And he moves all the way down to what if 10 are found. And if you do not know that, go into a church and ask them about the account of Abraham and Lot and Sodom and Gomorrah. And we have some of our legal underpinnings in Western society based on these biblical principles, where Abraham was basically able to reason with God and debate and negotiate with God down to 10 people. If there are but 10 innocent in this entire city of evil people, the entire city would be spared. Good night, Mario. And that's kind of where this formulation was based. Yeah, that is amazing. And with that little story written thousands of years ago, that's part of the basis of our present legal system, holding on to this ideal of innocent until proven guilty. The 12th century legal theorist Maimonides, expounding on this passage as well as Exodus 23:7, "The innocent and righteous slay thou not," argued that executing an accused criminal on anything less than absolute certainty would progressively lead to convictions merely according to the judge's caprice. Hence, the Exalted One has shut this door against the use of presumptive evidence, for it is better and more satisfactory to acquit 1,000 guilty persons than to put a single innocent one to death. There were several instances of this same thing popping up. Back in the Salem witch trials, back when that piece of madness was going on, Sir John Fortescue states that one would much rather that 20 guilty persons should escape the punishment of death than that one innocent person should be condemned and suffer capitally. Similar on 3rd October 1692, while decrying the Salem witch trials, Increase Mather adapted Fortescue's statement and wrote, "It were better that 10 suspected witches should escape than that the one innocent person should be condemned." Now, we see so many people writing about this through time. We see so many people writing about this through time. We see the underpinnings being dated back to biblical times, back to ancient times, where we saw this being based on this kind of ideal. John Adams, which was a United States founding father, also expanded on the rationale, and he basically explained why he held with this. He wrote, "It was more important that innocence be protected than it is that guilt be punished. For guilt and crimes are so frequent in this world that they cannot all be punished. But if innocence itself is brought to the bar and condemned, perhaps to die, then the citizen will say, whether I do good or whether I do evil is immaterial, for innocence itself is no protection." And if such an idea as that were to take hold in the mind of the citizen, that would be the end of security whatsoever. And I agree. I think this statement holds logical grounds. There would always be guilty people. In pretty much every single system in the world that ever existed, that exists currently, there are still guilty people. All guilty people will not be caught, will not be prosecuted, will not be punished. There would always be those. So, if some guilty people escape, that it is not ideal, but it is par for the course. It is understandable. It is the reality in every system. It is an error that cannot be avoided. However, innocent people being prosecuted is an error that more easily can be avoided. And if in a system you begin prosecuting innocent people, what Mr. John Adams was saying back then is the mindset that you would develop in your society is one where people will get the understanding, no matter what I do, innocence is not rewarded. So it doesn't matter whether I'm innocent or I am guilty, I might as well do the act. And okay, on the individual level, that's an amoral statement. There isn't any showing of moral superiority in such a statement. Whether you are punished by society or not, you should still do the positive moral thing. You should still do the good thing. And grand. On the individual level, if you're preaching a sermon to someone and you're trying to teach them something, if you're talking to your child, grand, tell them that. But when you're talking about society, you're dealing with incentives. So on a societal level, you're dealing with incentives. You cannot try to moralize everyone in society. You will not get through with that. You cannot impose your morality over the entire society by law. It is impossible. The way I see it is you cannot legislate morality. So what is needed then is an incentive structure that incentivizes people to want to remain innocent. And Richard Glubman says that as a criminal, he would be glad to hear people talking like this. Bravo60 over on YouTube says, just joined the feed here. Hope you watch the YouTube feed. Sometimes everyone is innocent until proven guilty in the court of law. It is not an accused person's fault. There is not enough staff or not enough electronic monitoring system. Not electronic monitoring. Our entire justice system needs an overhaul. I agree, it's not the accused fault. And you are right, Richard Glubman. You are right. As a criminal, they would be happy hearing this thing being said. A criminal would be happy hearing it said that it is better 1,000 criminals go free than one innocent person be punished. Criminals would be happy for that statement. You know who would also be happy? Innocent people. Yeah. Don't forget them. Don't forget them. While you pursue your vengeful idea on the criminals, bear in mind they are innocent people too. And that's the problem. Would you then, as I said, it's an either or. You cannot select both. If you do not lean on the side of allowing some guilty to go free in pursuit of making sure the innocent are not prosecuted, are not punished, then you're saying that you're willing to allow some innocent to be punished to make sure no guilty go free. And here's the damning part of that. There would always be some guilty going free. The person who makes the decision, the person who makes the decision to change the system to we make sure we punish some innocent so that we make sure all the guilty are punished may very well be a guilty person. Richard Glubman further goes on to say a person is not put in jail without evidence of guilt. Jail and prison are two different things. Someone is brought up on charges of murder with some evidence. Obviously not enough to automatically convict them. Then they still need to go before a court of law and be convicted. So if they are not yet convicted, the evidence cannot be yet said to be enough to say this person is a murderer. This is insane. I do not understand this avenue of argument that Richard Glubman so often goes down. What this basically does. Good night, oneness. Thanks, man. The vibe is always nice, I find, but yes. So what this eventually results in, where you're saying basically that once someone is charged, once someone is put in jail, there's evidence of their guilt. What you're saying is you're okay, as someone put it there, as someone spoke there about Judge Dredd, you're okay with the police being the judge, jury, and executioner. If the police decide to charge me with a crime, well, if the police decide to arrest me and they get permission from the DPP to charge me with a crime, then that's enough for guilt. I shall be condemned to jail. That is insane. That's not the way the system works. The police arrest you for the crime. The DPP decides, okay, there's enough to charge this person. You are charged. But then we still go through the entire process to make sure the person is guilty. The reason we go through all of this process is to make sure innocent people are not prosecuted. In this nightmare scenario that some police officers, some in the law enforcement fraternity, seemingly like Mr. Richard Gloveman, my resident police bubbly in the live here, the reason it has to go through that process is it must be proven. It is not yet proven. If it's not proven, you cannot yet say someone is guilty, and you do not want this evil system where innocent people end up trapped in it. If the court doesn't give bail and you found not guilty, the state should pay you, says Positive Radiation. I agree with that. The state should pay you if they held you inside of jail while the court found you innocent. Then you were held against your will, your freedom was taken away while you were innocent of all crime. But then, here's the thing. If I was in jail for 10 years, there's no amount of money. There's no amount of money that would give me back my 10 years of life. If I was arrested when I was 18 and I come out of jail near 30, my entire 20s stolen from me. My entire 20s stolen from me. And then you're telling me you're going to pay me. Even if you pay me $1 million per year, $10 million, grand, wonderful. You pay me $1 million per year. Still, I have lost my 20s. $10 million cannot give you back your 20s. How much money can someone pay you? How much money can someone pay you to tell you, all right, picture this. Someone has an injection where they're going to inject you and put you in a coma for 10 years. You're going to miss out 10 years of your life. How much can someone pay you to do that? How much can someone pay you to do that? Personally, me, there's no amount. You cannot pay me to do that. So, that is why, just as Richard Gloveman said, the criminals would be smiling. The criminals would be smiling at the idea of people saying it's better that guilty people. Rooney says she'll take $1 million a year to do it. The criminals, yes, they will be smiling at the idea of people saying it's better that guilty people go free than innocent people are punished. But at the same time, the innocent people would be smiling too. And yes, the case does go before a magistrate, etc. And that was the precise ruling that the justices made, Mr. Richard Gloveman. It seems like you are not following the case. The ruling the justices made wasn't that all murder accused are automatically going to be given bail. No, they said that the government's law, where they made an amendment to the bail bill, where they said that murder accused could never get access to bail, that was unconstitutional. And right now, what they're saying needs to happen is the murder accused would need to go before a judge, before a magistrate, request bail, and on the merits of the case, the judge will give bail or not. That is what the justices ruled. They didn't rule that all murder accused are all of a sudden going to be given $10 bail and they're going to be allowed free. No, they said that that authority needs to be wrested back into the arms of the judicial branch. Move it away from the legislative branch. That's why they said it was unconstitutional. The first part they spoke about was the part that it wasn't in line with people's individual rights and freedom. The second part they spoke about in their ruling was that it was unconstitutional because it removed that part of issuing justice, of ruling on justice related matters. It removed that part from the remit of the justice arm of our system and put it in the legislative branch. They passed a law that said murder accused people cannot access bail. The justices said that's unconstitutional. if you don't want a murder accused person to get bail, when they come to request bail in front of a judge, you show your evidence that this person obviously most likely is the accused. They're accused of this heinous crime. Look at the evidence here, judge. We're pretty sure we would make this case. Do not give them bail to go out there. Look, they're even a repeat offender. Grant, the judge does not issue bail. One of the judges even said that in this whole this whole series of events. They said most judges never gave bail to murder accused, even in common practice either way. So it's not like there needed to be that legislative move. The judges already made that decision. And what that precipitated from the Commissioner of Police. And I have to give props to the acting Commissioner of Police on this case, at least some amount. While some of these seem to be complaining about what needs to be done to make this happen, and this is impossible, and it's that, and it's that, and it's that, not understanding by arguing what they are arguing, they're basically throwing out the innocent until proven part of the judicial system. What the Commissioner of Police said: when are you going to do a show on the updates we so desperately need? What updates is that, Mr. Training over on Instagram? I'm not familiar. So, it's going to be back in the remit of the judges. That's what the justices said. It's not like they're automatically going to get bail. So, I don't understand. Well, I do understand the arguments in this, but I think I lean on the side of the justices. Personally, that's my personal opinion. Obviously, as I regularly say, my opinion can be wrong. But I find it hard to picture being an innocent person and you're in the jail there accused of murder. They put you in the jail. They have some kind of circumstantial evidence, let's say. You're pretty sure your case is going to prove you're innocent, but there's nothing you could do right now. There's nothing you could do. And as some people spoke about with, if you were in jail for so long and then you were found guilty, what's going to happen? The reality is, this case where this person spoke, where this case was brought before the appeal court to argue against this murder means no bail thing. That case was brought by someone who already suffered this. This was someone who was accused of a murder, spent 9 years in jail. It was found that they had no evidence of this, and after 9 years, they were released. So, if you tell this person, if you cancel this case, what you're basically telling that person, that individual that was in jail for 9 years, you're telling them that, well, we did the right thing. We jailed you for 9 years, found you innocent after the 9 years, but we find nothing wrong with that process and we'll do it again if it needs be. I think that is criminally, psychotically insane if that's what you're okay with. If you're okay with watching someone in their eyes after 9 years of jail, then finding them innocent and telling them, well, nothing is wrong with this process, nothing is wrong with this procedure, the system runs fine, we're going to leave it as is. That is insane. That is insane. And you're going to fuel a frustrated group of people in your society. And Richard Glubman, he sometimes in fervor to see he was not found innocent. I said it was found that they did not have enough evidence to prove he was guilty. The case was thrown out. Right. What some people fail to see is that in pursuit of justice, clamping down on justice in a society, you would do things like this. You would arrest numerous young adults. Very likely, you're going to arrest them from underprivileged communities, as we've already surveyed multiple times. And inevitably, you're going to arrest some innocent ones. And then from those innocent ones, you're going to create more bitterness. People who do not trust the system. And then when you end up with communities, entire pockets of communities that act like they do not exist within your legal framework, you're wondering why this community acts like they don't respect any of our laws. Because they do not respect your laws. They say things like your laws do not pertain to them. It's innocent until proven guilty. If you live somewhere else, you are going to encourage lawlessness in your society. You are going to encourage things like you see happening in our society now, where you would see 10 people going in multiple vehicles going to raid a business place. They don't have respect for the legal framework that we have right now. They have no respect for it. And you do not want a society where pockets of the society or large amounts in the society lose respect or trust for your legal system. And yes, even if you don't like them, even if you find probably you should put some added pressure on them, maybe you cannot. Because if you do, it's going to backfire on you and your entire system would be ungovernable. So yes, you may get that partial victory of feeling self-congratulatory, of making sure all murderers must stay in jail. None of them get access to bail. And okay, fine, you win that battle. But in the long run, the war that you lose is the battle for your society as it becomes ungovernable going through time. It is what inevitably happens. It's what happened in many of those partial societies, in many of those apartheid type societies out in South Africa, etc., where one group of the society, the laws worked for them, and another group of the society, the laws didn't work for them. Then what are you going to expect to happen with them? Eventually, when they recognize the laws don't work for me, they're not going to care for your laws anymore, sir. All right. Moving on from this. The case, the very unfortunate, tragic, sad case. I saw someone, as I said all these words, in the comments on one of my videos to do with this very sad, tragic case, to do with the Venezuelan immigrant baby that was unfortunately killed in their passage across to our island. I read in one of the comments with that someone was saying that in all that I spoke about this, I never even said rest in peace to the baby, and I somehow that makes me heartless or something to that effect. Sorry, I'd like to say it again. I am not happy that this happened. I highly doubt anyone is happy that this happened. No one is happy that a little baby lost their life. I am saddened by that. I wish it never happened. However, I saw the reasonable circumstances that led to the Coast Guard making that decision. However, there seems to be contrary witness statements now. A Trini fisherman is saying otherwise. Trini fisherman disputes Coast Guard account of babies killing. They say we shoot at them, which is not true. We didn't have no guns. We didn't have no drugs. Nothing. We are fishermen. We went just to assist. It could be Trinidadian. It could be who. So said one of the Trinidadians aboard the boat that 1-year-old immigrant baby was on when he was shot and killed during the early hours of February 6th. The fisherman, who asked to remain anonymous for fear for his life, said there was rapid gunfire when the Trinidad and Tobago Coast Guard vessel came upon their boat. The 31-year-old man of Marugas yesterday gave an account from his lawyer's office of the 45-minute drama which saw him being told by the Coast Guard to lift the body of the dead child and pray for him. How he ended up on the boat, don't worry, his story is coming. His account is coming. And you could tell me if you find this account to be believable. I just be sleeping and I just be seeing this baby. I just be seeing myself with this baby. It's not nice. Every time I think about this and talk about it, tears come out from my eyes. The baby's eyes were closed. I was holding him just like when you pick up a little child, and I was looking down in his head. I had blood running on my hand, he said. The fisherman said he went fishing from Moruga with another Trinidadian and the Spanish-speaking captain after 5 p.m. First interesting fact, the captain of that vessel was a Spanish-speaking captain. But they were going to fish. That's what the fisherman said. The Spanish-speaking captain and these two Trini fishermen were going out there to fish. All right. And during the course of the night, they saw a boat, smaller than a pirogue, which seemed to be in distress. How the light was waving, we say like this boat in danger. We went to them. The captain of the boat I was on was a Spanish national. He was talking to them to find out what really going on. And they were explaining to him what was going on. As far as I understood, they needed some help to reach ashore. So what Trini fisherman is saying there is that, you know, they weren't out here looking to do criminal activities, you know. They just went out there to fish. They just went out there to fish with their Spanish-speaking captain, and they happened upon a small vessel in distress. They just noticed a migrant vessel in distress, unfortunately, you know. But something I noticed very interesting in that statement said by that man there, where he said that where he said that they went out to fish and they happened upon this smaller vessel in distress. I found that statement interesting because it sparked my memory. I remembered something about that. A story I read. I don't know how many of you are in all of the lives, but in one of the mindful lives in the heyday of all of this, I went through a story where lawyers for the migrants on the vessel, the illegal migrants on the vessel, got lawyers. How many of you remember that? The illegal migrants got some lawyers to speak on their behalf, and these lawyers were saying that these migrants are now witnesses. These migrants are now witnesses, and they're saying that their witnesses have to give a statement. And their witnesses did give a statement. I'm trying to see here if I can find that story quick enough to pull it up over there on the YouTube live. I believe I found it. Where they gave a witness statement. Let me see if it's this story I remember here. Lawyer gives Hines 24 hours to respond to migrant refugees status requests. And they basically gave a witness statement, right? Excerpt of witness statements given to representing lawyers. Following their departure from Tucupicha, Venezuela, this is the Venezuelan internationals on board the vessel. This is their witness statement. Following their departure from Tucupicha, Venezuela on the night of February 5th, 2022, a boat with 37 passengers, inclusive of 17 adults and 20 children, made its way to TNT. At departure, their boat had 2 engines. One had difficulty and kept cutting off. Upon approaching Moruga, Trinidad, the engine cut off once again, and they had difficulties moving in the water. As they were slowly coming along, they heard a loud voice followed by 2 flares. One flare was shot into the air and the other flare was fired at their boat. Oh-ho. All right. So the Venezuelans on board the vessel, in their witness statement, They never mentioned anything about switching vessels. They didn't say that they were on one vessel first and then they switched to another vessel when it got into difficulties. They didn't say that. And now listen to the order the Venezuelans spoke about the flares. As they were slowly coming along, they heard a loud voice followed by two flares. So they heard a loud voice followed by two flares. One flare was shot into the air and the other flare was fired at their boat. Okay, now bear in mind, this witness statement was given when this story was 13 days ago. This was 2 weeks ago. This witness statement was given. Now the Trini fisherman on board the boat is saying that no, they didn't pick them up quite over in Venezuela. They saw this vessel in distress right out in the sea in the night, and they decided just to help these migrants out of the goodness of their heart. Okay. He said they transferred the occupants to their boat. So we're back to the witness statement from the Trini fisherman here. He said they transferred the occupants to their boat. And when they were about 10 to 15 minutes from the shore, they saw a big boat in the dark. It didn't have no lights or anything. We saw a flare. We didn't know if it was bandit or if it was Coast Guard. Do bandits out in the sea generally shoot flares? And he said he saw a flare. He didn't say anything about the loud voice. Because the Venezuelans said they heard a loud voice before they saw a flare. All right? We heard several gunshots, rapid fire. I was in shock. I thought it was firecrackers. I was really frightened. They sent up a next flare with several gunshots still. After the second flare, they sent up a third one where they put on a light and on their boat saying it's Coast Guard. Stop, he said. Now, my problem with this guy's witness statement is it's very confusing. I don't understand the full order of events here. I think if you're giving a witness statement, you need to give clear chronological order. So they sent up a flare. After they sent up a flare, we heard a burst of rapid gunfire, approximately 30 shots. Then they sent up two more flares without saying anything. The boat was approximately 100 meters away still. Then they let off another round of fire, this time twice as long as the previous first round of fire. And then they turned on the light and announced it was Coast Guard. Give me something in order. This is just a jumbled set of information thrown out there. Bullets flying. He added, all right, it's Instagram's time to give some trouble as per usual, apparently. Yeah. I think that may be the end of my Instagram live. Is it still working? Am I still live over there on Instagram? Instagram is the usual fight down, and TikTok always behaves itself so appropriately. But Instagram always there to, show itself to be as it is. All right, let's see if we can pull this up better here. All right, we live. Instagram has decided to go bye-bye for the moment. Fisherman innocent, of course. All right. Bullets flying. He added that he was standing in front of the boat's engine and the bullets were flying close to his head. The fisherman said while they abided with the command to stop, the boat could not immediately come to a halt. He said two smaller boats came to either side of their boat and the Coast Guard officers began asking for guns and drugs. We were telling them a baby died on the boat here and the mother got shot. We have nothing like no drugs and guns. We told them it's just these people we saw in need of help. We just saw these people in need of help. We have no guns and drugs aboard. Now, to me, what he is saying there actually gives some truth to part of to part of the Coast Guard's account. The Coast Guard said when they pulled up to the boat, they didn't know that it was migrants on the boat. They had no idea what this boat was carrying. They pulled up to the boat, and according to the fisherman that was on board, he seems to kind of admit that when they pulled up to the boat, the Coast Guard officers were asking for drugs and guns. Now, if they pulled up to your boat asking for drugs and guns, that kind of says something to me. It says that they kind of believed for some reason that you were carrying guns and drugs. Now, here's part of this that I am just wondering about, right? If these men were just regular fishermen, right? Two trainee fishermen on board of a fishing vessel captained by a Venezuelan captain. If that's all that this is, that's all that was going on there. Okay. Then why would the Coast Guard find you moving suspicious enough to stop you? What about your action caused the Coast Guard to stop you in the first place? Is it the custom of our Coast Guard officers, when they bounce up upon fishermen out in our waters, to shoot out flares and start shooting at the fishermen? Does that make sense to anyone? How often do you hear fishermen saying that Coast Guard officers randomly saw them out there fishing and started shooting at them and shooting flares into the air? Why did what made the Coast Guard pay particular attention to this particular fishing vessel? What about your fishing vessel, Mr. Fisherman, sir, caused the Coast Guard to find it so interesting? There had to have been something. The Coast Guard had to see something about your vessel that made them say, I want to stop this vessel. The motion of the craft. Quite possible. There was obviously something about the movement of the craft that made it obvious something isn't. It's not just fish these men came out here for. And then, in that case, this fisherman's story obviously has some pieces missing. I don't believe that fishermen went out there so coincidentally happened to have a Spanish-speaking captain, so coincidentally happened upon a migrant vessel loaded with migrants that they took on board just out of the kindness of their heart. Now, bear in mind, if you are a fisherman and you went out into the sea to fish, and you took on board all of these migrants and were going to drop them on the land, you should know that you're committing a crime. If you are a fisherman, you found migrants stranded out there. The first thing you have to say is you have to try and find a way to get Coast Guard involved. Here now, I call in the Coast Guard right now. I looking for a Coast Guard vessel. But it doesn't add up. It just doesn't add up. Now, I would like to believe the guy's story, but it just doesn't seem quite plausible. What you all think in the chat? Tell me in the chat whether you think this account from this fisherman on board this vessel, whether you think this account was correct. Tell me in the chat. Where's the migrant vessel? They are not fishermen. Well, they are immigration officers. It could seem so. It really could seem so. Something doesn't add up with that story. All right. On that note and on that troublesome Instagram note also, I will bid you adieu over on YouTube there. I will be over here on TikTok for a little while longer. If you'd like to come join me, feel free to come here. But that's all I have for now. I hope you're educated, informed, or entertained. And I'll see you again tomorrow for the next Mindful Live starting around 9:30. Until